So first of all, I'd like to introduce Charlotte Turnbull, who's the Head of Employment at W Legal. Charlotte has significant experience in dealing with non-contentious and contentious matters for both employers and employees on topics including contracts of employment, disciplinary and grievance issues, discrimination and equal pay, family and pregnancy related issues, flexible working and unfair dismissal. So she's been quite a busy bee, I should imagine, recently, and may continue to be so. And I also would like to introduce you to our other panelist, who is Daniel Baum. And he is an expert accountant and founding partner of Cameron Baum Hollander. And he is well known to us all. Some of you may have seen him on one of our previous webinars. And Daniel is going to set the scene for us to introduce the whole topic of furlough, given that that's the particular focus for this evening, and help to introduce the whole subject, explain what's been happening and what is coming next. So over to you, Daniel.
Okay, thank you very much, Ros. Good evening, everyone. So the topic is post-furlough, what comes next? And I want to introduce it with an anecdote. One evening in 1946, in the Houses of Parliament, Sir Winston Churchill was allegedly accosted by a Labour MP by the name of Bessie Braddock, the MP for Liverpool. "Winston," she said, "you are drunk, and what's more, you are disgustingly drunk." Winston replied, "Bessie, my dear, you are ugly, and what's more, you are disgustingly ugly. But tomorrow I shall be sober." This verbal joust between two MPs, which is now, of course, totally politically incorrect, perfectly sums up the post-furlough situation. It is soon to be the morning after the night before, and post-furlough, the economy remains ugly. The virus is not under control, the vaccine some way off, the economy is in tatters, and jobs in many sections of the economy are at great risk. The furlough scheme, which has been in operation since March and will be until the 31st of October, when it will end, has cost the economy £36 billion, and over 9.6 million people have been furloughed. Originally, the furlough scheme until June subsidised 80% of an employee's salary, and that is now being reduced. As of next month, it will drop to 60% before it stops. So what comes next once the furlough morphine has worn off and employees and employers are faced with hard choices? I'm afraid that for employees, particularly in the entertainment, hospitality and travel industries, it's going to be a very difficult time indeed. I think the important thing is for employees to know their rights, which I'm sure Charlotte will address, and to ensure that any process of redundancy is done fairly. For employers, I would remind them that there is still government help available. The bounce back loan, which is a £50,000 loan capped at 25% of turnover, is still available. And the benefit of that is no repayments at all in the first year. There is £1,000 per employee job retention, which will be paid in February for all employers who keep on previously furloughed employees. And there is the Kickstart scheme, which is encouraging employers to take on 16 to 24-year-olds. So for employers, there is a little bit of help available. For the self-employed, the government help also ends shortly, but they should make sure that they make their claim if their profits on average were below £50,000. For residential landlords, there's almost no government help. The help is really focused on tenants who until the 20th of September cannot be evicted, and even then landlords have to apply to the courts to do so. And commercial property is in the doldrums. So in the short term, I'm afraid post-furlough, I can only see bad news. What should be done? Businesses need to innovate. They need to, perhaps in some cases, change course entirely. Some of my clients have been extremely proactive and successful in the COVID, and there is no doubt that the internet and use of social media is increasingly important. There is an opportunity to slash property costs, but of course, this takes time. But until there is a vaccine or the government gets a grip, as the furlough scheme winds down, I'm afraid that redundancies will be the order of the day for many. By the way, for those of you who felt Sir Winston was a touch harsh on dear old Betty, she was no soft touch. Known as battling Bessie with an acerbic tongue, there is a statue of her in Lime Street Station. But of Sir Winston, there is a statue both in the Houses of Parliament and in Parliament Square. Thank you.
Thank you very much. Thank you, Daniel. A really excellent introduction, setting the scene for us. Perhaps not a laugh a minute, but I loved your anecdote. And I would love now to introduce you to Charlotte Turnbull from W Legal. Charlotte, if you could give us a quick introduction to what you do and how you see things, and then we'll go on to questions.
Thank you, Ros. Firstly, Mercy, I'm delighted to be here, and I really hope that I can add some value and assist our viewers in understanding the various legal aspects in relation to employment law during this pandemic. As my co-presenter Daniel mentioned just now, redundancies probably are going to be the order of the day going forward. There are two areas which I'm being consulted on at the moment. The first one is redundancy. The second one is in relation to sort of workplace flexibility in terms of flexible working from home, that kind of thing. So they're going to be the two largest things that I think are going to be important to employers, especially once the furlough scheme ends and people are coming back to work. The redundancy situation, nothing much has really changed. It's as it always was. Employers are allowed to terminate employees for redundancy in certain situations, and there are proper processes and procedures which employers must follow. The second area, the sort of flexible working from home, is a lot more fluid. In 2019, the government pledged in its manifesto to make flexible working the norm as one of its policies to combat workplace inequalities. However, the government are now promoting a return to the office to save the economy. So those two sort of political views are now conflicting. Prior to the 1st of August, the government advice was those people that can work from home should stay at home and work from home. Now we need to get everybody back. So it's very mixed messages, and employers don't really know what to do. Working from home is one way of dealing with keeping employees safe, but there is a lot of uncertainty, and I'm hopefully going to come on to that and address that a little bit later on.
That's lovely. Thank you so much, Charlotte. So we've already got some questions coming in, and anyone out there, if you've got more questions, please keep them coming. If I could start with you, Charlotte. A question from someone who has sadly been made redundant, who says, I was made redundant and I was furloughed after I accepted redundancy. I finally received my redundancy payment, but it didn't match what I expected. The redundancy package wasn't explained clearly during consultations. HR was misleading during the initial meeting. And it seems that what they did was legal, but for some reason they led me to believe that it would be different. Is there anything I can do about it?
Thank you. It's a very interesting question. It's always very difficult to give sort of very specific advice. But generally what I can say is if an employee has 2 or more years service, they are entitled to receive a redundancy payment. Often that's a statutory amount. Some employers will have a contractual enhanced payment scheme that they operate. But most people will rely on the statutory minimum, which at the moment is capped at a maximum of £538 per week. And redundant employees entitled to a week's pay for every year that they've been there, although this can vary dependent on the employee's age. I don't know what this viewer actually was led to believe they would receive and what they actually received, but it may be that actually they've received what they are entitled to under law. It may be that they haven't. If they were to have signed what's called a settlement agreement, offering them an enhanced sum, and then a payment's not been made under that, that's a completely different situation, and they might well have a claim for a breach of contract. That wouldn't necessarily be an employment claim, it'd be a claim that would be brought in the courts, but we could obviously advise and assist on that. Or it may be that actually they've received less than they expected, because when they've calculated the week's pay under the statutory scheme, the employer's calculated it on the amount the employee received under the furlough scheme rather than their full pay, and that's actually not allowed. So they would absolutely have a claim there. There might be some questions there about whether the selection for redundancy was unfair. The viewer has said that they were misled during the process. So perhaps a fair process wasn't followed, and it might be that there's a claim there for unfair dismissal as well. I would be happy to speak to the viewer privately on this, but it's possible that there might be some action that they can take.
Well, one question that's come in, which is directly related to this, is are the employment tribunals up and running at the moment? And will they be able to cope if there are large numbers of cases?
Well, that's two questions. They are up and running at the moment. We're not suffering too much delay. I made an application with the tribunal. It took them about 6 days to come back to me, so not too bad. Whether when things fully get back to normal they'll be able to cope is anybody's guess. As you probably know, the judicial system's under a lot of pressure, lots of cost cutting, closing of courts, closing of tribunal buildings, that kind of thing. I don't know. I think we're going to end up dealing with quite a lot of backlog, which in employment cases is really serious, because this really affects people's lives. So we don't obviously want things to drag on for any longer than is necessary. But who knows? I suspect it will be a bit slower.
Okay, a quick question or two for Daniel, and for all of you watching out there, I'd like to make it clear that both Charlotte and Daniel are not offering anybody advice tonight. This is information, guidance, help for you. But if you want actual individual advice, that's not something that we would be dealing with here. But we hope that the answers will be helpful. And I think already you can see the quality of the expertise that we've got here for you tonight. So Daniel, a question for you. I'm a self-employed beautician and have just found out about the grant for the self-employed. Can you tell me what I need to do to claim it?
Yes, so this is a government programme which was to help small self-employed business people, sole traders, partnerships. It was brought in because the employees were getting their furlough scheme, and the self-employed were quite rightly saying, well, what help do we have? So the government brought in a scheme where they said if profits in the previous year, or the previous 3 years average, were £50,000 or lower, then a self-employed person, in this case this beautician, could make a claim for 3 months' profits to be paid to them as a grant. The first tranche was for April, May, June, and the claim had to be made by the end of July, and that's closed. So anyone who didn't know about this scheme has now missed tranche 1. Tranche 2 for July, August, September is still open. They should contact the Revenue Office, and as long as this beautician's profits has been less than 50,000, they will get 3 months profits capped at £2,500 per month. Capped, that was 2,500 was the first time round. This time it's a lower cap of, I think, 2,175. So they will get a cheque from the Revenue of 6,875, 3 months profits. That's what this beautician can do. But 19th of October is the deadline date to make the claim. After that, you've missed it.
Okay, so anyone out there in that position, make sure that you get your claim in.
Yeah.
Thank you, Daniel. Charlotte, there's a couple of questions that have come in from the audience. Maybe if I ask you them both for now. Carol asks, if I get made redundant at the end of furlough and I am 66 and receiving my state pension, can I claim any benefits? Question one. And Avril, do employees on 0 hours contracts have the same rights as others?
Okay, so in relation to the first one, the lady that's 66, I'm not sure about benefits. It's not my specialist area, but I do know that she may not be entitled to a particularly large redundancy payment. Dependent on what her employer says, they might have a contractual redundancy procedure. If they don't, it goes on the statutory amount, which tapers the closer you get to retirement age, and retirement age keeps moving. So there's a very high possibility that there would be no redundancy payment. I'd be happy to have a look at that after the webinar if that lady would like some further assistance and guidance on that.
I can also tell Carol that if she's getting a state pension, she wouldn't get any universal credit or the old unemployment benefit or any of that, because the state pension trumps those, and it's worth more anyway.
Yeah, thank you for that. That's, like I say, it's not my area of expertise. It's not something I know a great deal about. And remind me the second question, please.
Do employees on 0 hours contracts have the same rights?
Yes and no. If they are a genuine employee on an employment contract, they attain the same rights as any other employee. And the way that any redundancy payment would be calculated would be looking at the previous earnings over a set period of time. So they'd be able to look at how much that person earned. And if it was the same or greater than the statutory minimum, it would be that £538 a week for every year earned. If it was less, it would be the actual amount based on the average earnings, but that person would still have to have at least 2 years service to be able to be entitled to the redundancy payment. We do have some employees on what's called 0 hour contracts that actually aren't employees at all, and they would have no rights. But then we would need to look at actually whether the way the relationship was structured, albeit they were not treated as an employee, whether in fact under law they might actually be an employee. And that would be based upon a number of different factors, including the amount of control they had, whether they used their own equipment, whether they had to wear a uniform. There's all sorts of things that would come into consideration when trying to calculate that.
That's what happened with Uber, wasn't it?
Yes, yes, and the Pimlico plumbers.
Yeah, Pimlico plumbers, that's right. Oh, well, thank you. And I hope all of you out there are finding this helpful. Thank you for all your questions coming in. We're going to keep trying to get round to more, so please keep them coming. Daniel, question for you. I took on 2 extra staff in April as I expected an increase in business, but since the end of August, things have gone quiet. Can I furlough them or do I need to make them redundant?
Okay. The furlough scheme, although continuing until the end of October, there are 2 parts to it. The part that ended on the 30th of June, part A, shall we call it, where the government paid out 80% of the salary. When that ended, if somebody hadn't been in the furlough scheme, hadn't been furloughed, they actually couldn't qualify for the second part of the furlough scheme. So somebody who joined in April and was being paid a full salary and working, suddenly in July or August find themselves that the employer doesn't want them anymore, cannot get onto the furlough scheme. It had to have actually been registered as furloughed earlier on. So in this sad case, the person who joined, or these 2 employees who joined in April, cannot get onto the furlough scheme. And the redundancy, as Charlotte pointed out, they have not been, they haven't done 2 years service. In fact, they've probably only done about 4 months service, so they won't qualify for redundancy. What they would get would just be determined by what was in their employment contract, possibly 1 week's pay. So sad news, I'm afraid.
Okay, thank you, Daniel. Charlotte, another question from the audience. This is about a secretary who was furloughed at the beginning of the pandemic and then asked by her employer to come back to work around July. She didn't want to because she's a young single mother and was difficult managing both her home and work, and the children were not yet at school. And she also felt that the place of employment wasn't properly COVID secure. Her employer has now dismissed her, or in his words, regarded her as having resigned because she refused to come back to work. Are there legal guidelines as to, one, whether an employer in such a situation is allowed to do this, and two, if not, whether the secretary would now have a claim for unfair dismissal?
Thanks, Ros. Again, it's another really interesting question and a set of circumstances which is not particularly uncommon at the moment. Obviously, all the schools and nurseries and other sort of childcare settings closed down back in March, and it's caused a huge problem for working parents, especially for those people that are in single parent families. They don't have anyone to share that burden with, and also they weren't able to rely on family members to help out with childcare because we were all socially distancing. What has happened is, even before the pandemic, there's lots and lots of cases where employees can show that they have been indirectly discriminated against on the grounds of their sex, when women, and it tends to be women, are treated differently because of childcare issues. So employers do need to be quite sensitive to this. We are in really difficult times at the moment. Nothing like this has happened before. And if people genuinely have no childcare, what are they supposed to do? And to dismiss somebody probably is going to be an act of sex discrimination. In addition to that, obviously, we've got the issue of the workplace not being properly COVID secure. This is actually a potential breach of health and safety legislation. So all employers have a duty to protect the health and safety of their workforce. And if employees genuinely feel that it's not safe to go back to work, and they can show why they think it's not safe, perhaps their employer hasn't done a number of the things that the government has recommended, and they genuinely fear for their health, they're entitled to not go to work. They're entitled to be paid for when they're not at work. And if the employer dismisses them as a result of that, the employees have a right not to be subjected to detriment. And both of those claims, the potential sex discrimination claim and the right not to suffer detriment under health and safety, neither of those claims need the employee to have 2 years service. So it's really dangerous territory for employers to take that action without taking advice. Because somebody could have been working with you for just a month, bring that claim. If they're successful, those discrimination claims, the compensation in the employment tribunal is uncapped. So it's a potentially very, very costly mistake for employers to make. Equally, for employees, if this has happened to you and it happened around about July, you will need to take some action very, very quickly. You'll have 3 months in which to bring an employment tribunal claim. So you haven't got that long left. So if you wanted to take some advice on that and bring a claim, you need to do that very, very quickly.
Yeah, that's really important, actually. You know, if you have a grievance, you need to be within the timescales, and there's only the 3 months. So
yes.
Be very aware of what's happening around you at the moment, and I think this could apply to a lot of people. I guess an interesting question is, would people who worked in hospitals or care homes who hadn't been provided with protective equipment be entitled to just say, I'm sorry, I'm not coming in? It's amazing that most of them came in and took that risk upon themselves, but could they have an action against their employer?
Again, that's a great question, and it really does depend. If you had somebody that was high risk, so they were in the shielding category, the critically vulnerable, they probably would have a right to not go to work. If you had somebody that was in full health and was not provided with PPE, maybe they would have a right not to go to work as well, because they are putting themselves in danger and their employers not providing them with a safe place of work.
It seems so difficult for employers. And
Yeah.
I think one of the big issues is, I don't know if you've come across this, Daniel, but employers who can't get insurance now because the insurers are worried that if they haven't got strict health and safety protection mechanisms in place, it's a small employer or a small place of work, yes, they could be liable for action.
Yes, I haven't come across it from my clients being unable to get insurance, but it's probably something that's going to crop up as time goes on, and claims are made, and you suddenly find the insurance you thought you had isn't working.
Yeah.
Yeah.
I think that definitely is something that needs to be checked.
Mm.
Another question for Charlotte. Philip has asked a question. Surely working from home will be doomed to failure for a great many people in the long term when employers realise that they can outsource jobs overseas at lower salaries and thereby provide great savings in UK office space and staff costs, which will no longer be required at the same pre-COVID levels. What would you say to that?
That's a really good point, actually, and something which not a lot of people have considered so far. But I mean, we already do have certain people in the legal industry, for example, that outsource elements of their legal practice to other countries where they can get the same good quality advice, a fraction of the price.
Really?
I would argue it's obviously not quite the same. But no, it is a real worry, and the same argument would actually go for regional salaries as well. Why should some employers pay a London salary when actually a person could do that job from home, sat anywhere in the country? But I think that might be a little bit scaremongering, because I don't think the office is dead. I think that we are social beings as human beings. We still like to interact with people. We still like to go into the office. A lot of business is still done face-to-face, meeting up with people at networking events or meetings in person. I don't think that any work will be done completely remotely. I just think that there'll be a lot more flexibility in the way in which people work. Yeah, I mean, from a legal perspective, I'm not sure there's an employment law answer. I think it's just obviously given my point of view.
Daniel, do you have any comments on that one?
I think it's a very good question, because many accountancy firms outsource the sort of lower level work overseas where it's much cheaper. And if you don't need somebody sitting in your office, then why do you need them sitting in the UK? It makes no difference. I can't comment on the employment aspects. That's not my area, but it's quite likely that at the bottom rung of the work, processing will be outsourced.
Yeah, and well, a lot of it's already been outsourced, hasn't it?
It is already.
Call centres overseas and so on.
Yeah.
And actually, what you saw before the pandemic was that employers started to reshore jobs because they felt that the quality was better in the UK, and customers were not always happy to be dealt with by overseas entities. But if they're not customer facing, then that's a lot less risky, isn't it?
That's right. Yeah.
A question for you, Daniel.
Mm.
My manager has been with me for 10 years and last year earned £45,000. I need to make him redundant. What is his entitlement?
Well, I hope I get this right, because it's really Charlotte's area. But the rules are that...
Charlotte, you keep an eye and make sure this is right, okay?
Don't say anything if I get it wrong. The first 2 years, as Charlotte said, the person cannot claim redundancy. This person has been with him for 10 years. So they've done 10 years service. They are entitled to redundancy, certainly statutory redundancy. And the way it works is, as Charlotte said, there's a maximum cap of £538 per week for every year that they worked. That is increased if they are over, I think, 41 years of age. It's 1.5 times £538. Or if they're under, well, they wouldn't be under 21, they've been there 10 years. They didn't start at 11. So if they're between 20 and 40, it's 538. If they're over 40, it's 538 times 1.5 times 10. And that would be That would be the redundancy package.
Okay.
Yeah,
Thank you.
there's nothing else.
Anything to add there, Charlotte?
In terms of the redundancy package and the statutory redundancy calculation, that's absolutely right. The employee might also be entitled to a payment in lieu of notice if they're not going to be working any notice. They may also be entitled to other benefits to be paid up, or possibly holiday that they've accrued but not taken. But obviously that would depend on the facts.
Okay.
One extra point is that the redundancy package is tax-free up to a maximum of £30,000.
Right.
Holiday pay not, but redundancy is a tax-free payment as long as it doesn't exceed £30,000.
Okay, good.
Just worth knowing.
And another question. There's been talk in the newspapers about the furlough scheme having been abused and some claims being either wrongly made or fraudulent. Should people be very careful about this situation, and what could the government do if they discover that somebody has misused the furlough?
Yes, I think the government, if it's intentional and not an innocent mistake, I think the government will come down pretty hard, and there will be fines. I don't know what those fines will be. I don't know if they've been published, but there has been an opportunity already, and it still exists, that they are encouraging employers to go back now, things have calmed down, and check, first of all, their furlough calculations.
Yeah.
If you've made an innocent error, you just inform the revenue and it'll be corrected. You'll pay back the amount, or they'll deduct it from the remaining furlough payments. I don't know how many people have come forward and said, yes, I actually fraudulently claimed it. Probably
They're not going to say that, are they?
No, but there have been, and I've anecdotally heard of some businesses flagrantly abusing the furlough scheme.
Yeah, I've heard of that too.
And often they've done so, I think, in order to try and survive, but that's not a good enough reason, so they claim. And I would encourage them to sort it out, because no good will come of it. And I think the government, this morning I saw in the newspaper talking about £3 billion.
£3.5 billion, yeah.
Right, a fraudulently claimed furlough, and the government will want that back. Yes.
Charlotte, have you had any thoughts on this?
It's going to be very interesting, actually, and I'm aware that there are some larger companies that are voluntarily making repayments to the government, not because they've done anything wrong, but because they are in a position to repay the money now. So that's great, and we should all be sort of applauding them for that. Equally, in relation to the fraud, I'd be concerned that there might be some people that are inadvertently breaking the rules. So I was speaking to somebody the other day who's on furlough. She's having a lovely time. She's got a young son, and they're having lovely family time together, and it's great. And she mentioned to me just in passing that she's still attending team meetings via Zoom every week, sometimes several times a week. And that's not allowed. No, you're not allowed to do any work. And I wonder whether there might be some people that are genuinely inadvertently breaching the rules. And I wonder how they might be treated. Because that is a breach of the rules, but it doesn't seem a serious one, but it is against the rules of the scheme. And I expect there might be lots of people that have done the same, trying to keep their employees sort of up to speed so they can come back, and actually it's not permitted.
Okay, if any of you have any last minute questions, we've got another few minutes to go, and let me just ask you another couple of the questions that have come in, but we'll be happy to try and take any other questions if you want to send anything in. Charlotte, employees are returning from furlough and may now want to book paid holiday. Do employers have to allow this after the furlough?
Yeah, so this has come up quite a lot, actually, and I've spoken to some business owners who have been quite categoric that if people come back to work and they then want to take time off as holiday and I've got to pay them for it, they've got another thing coming. But actually, they're really wrong there. When people are on furlough leave, they continue to accrue their annual leave entitlement in the usual way, the same as you would if you was off sick or if you were off on family leave. So under the working time regulations, all full-time employees must be granted at least 5.6 weeks paid annual leave. That works out at 28 days, including bank holidays. Contractually, employees may be entitled to more. Now, what employers can't do, well, they can refuse a worker's holiday request. If somebody says, I want to take this particular week off, an employer is within their rights to serve counter notice and say, no, that's not convenient, you can't take that particular time. But what they can't do is stop them from taking the holiday. That would be a breach of the working time regulations, and would probably land them in an employment tribunal. At the beginning of the pandemic, the government did introduce some emergency legislation in relation to holiday, and they relaxed the restriction on carrying over of annual leave. So what I think might happen is employers might say, no, you can't take it now, but rather than you lose it at the end of this holiday year, which might be end of December for most companies, or some other month, maybe the end of March in line with the tax year for some other companies, is they might actually say, we will allow you to carry it over for next year, but they can't stop employees from being entitled to take that time off, and they are entitled to be paid.
Can they require the employee to take it, let's say, between Christmas and New Year, even if they didn't intend to?
Yeah, so that's always been the case. Employers are entitled to serve notice on their employees and tell them that they must take their holiday between certain dates. That's often in between Christmas and New Year.
So there might be a way around it for an employer. You know,
yes.
I want to take my holiday now. Well, sorry, I'm going to pay you for holiday, but only when
I tell you to.
I tell you.
And likewise, actually, if people are still on furlough at the moment, the employer can avoid this situation by requiring them to take their annual leave now, so that they don't have any when they get back. But what they would need to do, if it's during this furlough period, they would need to top them up to full pay, because they have to be paid holiday at their full entitlement.
Yes, I've actually heard of employees who've said, I'm on furlough, there's no way I'm going to take actual holiday now. And as you say, some employers have wised up and decided, well, if they're on furlough anyway, I'm going to make sure that I tell them to take holiday now, otherwise I'll be in trouble later. So
yeah, absolutely. And for businesses, it really makes sense to do that, provided they can afford to pay that top up. And employees, unfortunately, can't really refuse that. The advice to businesses would be to get your employees to take it now. The advice to employees would be to take it when you get back if you can.
Yeah, I think you've probably just answered Rachel's question, which has just come in, regarding holiday following furlough. I was told to take a week's holiday during furlough, during which time I was paid 100% of salary. Was that allowed? Basically, I think you've just said that was what the employer would have to do.
Yeah, absolutely. They have to give you notice, and then as long as they pay you the full amount, that's absolutely permitted.
How much notice do they have to give you?
It's usually the same amount as the amount of leave they want you to take. So if they want you to take a week off, they've got to give you a week's notice.
Right, okay. And Daniel, a question that's come in from someone who doesn't want to be named. Do employers have discretion to terminate furlough whenever they want to?
Do employers have the discretion?
Yes.
My understanding is yes. An employer can decide that that they no longer wish to furlough the employee. What they do with them after that, well, presumably redundancy is either they're
they have to consult for redundancy,
or maybe they want them to return to work, and the furloughed employee is quite happy being furloughed. I don't quite know in this instance what's to follow, but maybe Charlotte, correct me. I believe that the employer can decide to take an employee off of furlough as and when they decide to do so. Whether that's followed by bringing them back into work or redundancy is up to the employer.
Yeah, it sounds to me like this question is from someone who has been asked to come back to work without much notice.
That's what I was going to
furlough.
Yeah, that's what I was going to add. At the moment, there's no law in relation to how much notice they need to give for employees to come back. What I would say is employers really need to be mindful of how much notice they do give to people, especially if there are childcare issues. Thankfully, the schools are back, so hopefully that's not going to be such a big problem going forward. But it's not really fair to give somebody only a day or two's notice to come back when actually they've got to sort out childcare or perhaps other caring responsibilities or something else they've got going on in their personal life. So there's no set limit, but employers should be very careful and give as much notice as they can, really, just to be fair and decent, and to bear in mind they might inadvertently discriminate dependent on who they're dealing with.
Okay, there's a couple of final questions. We're just going on an extra few minutes because we've had so many questions to deal with. So first of all, thank you to everybody out there who's been sending in the questions. And one more for you, Daniel. This is someone who says, I'm a residential landlord and my tenant refuses to pay the rent, even though he's furloughed and has been getting 80% of his salary. Can I force him to pay? Can I evict him?
Unfortunately, I've had a couple of clients who are buy-to-let landlords and have had tenants like this, and the answer is no. You can't force them to pay and you can't force them out. The government extended until towards the end of this month before a landlord can even take any action. And as I said in my opening remarks, the eviction process can take several months through the courts. So as unfair as it is, because although landlords are often painted in the press as sort of greedy capitalists, many landlords rely on that income for their own livelihood, and there's not a lot that they can do at the moment.
Yes, that's right. I've had a lot of angry landlords contacting me saying, this is my pension and I haven't got any money coming in, and now I can't do anything about it. I can't. Some of them had tenants who were in arrears before lockdown started, but there's not much they can do. So that must be difficult for them. Charlotte, I think one final question that's come in. Business performance has been impacted by COVID-19. Can I ask my employees to work fewer hours on reduced pay to match the reduction in hours?
Yeah, this is something that's quite common actually, and we saw this a lot in the financial crisis. Lots of people working 3-4 day weeks. The idea was that if everybody shares the pain, that everybody remains employed and people still have jobs and the business can carry on. Legally, an employer cannot unilaterally change an employee's terms and conditions of employment. So if everybody agrees to this, and often most people will, because they all want to keep their jobs, then it can be done by consent. An employer can't force an employee to do that. What they can do, and is a much riskier strategy, is to terminate them all and then offer to re-engage them on new terms. It's not a strategy I would generally recommend. If you've got people that have been there less than 2 years, it's very low risk unless they've got a protected characteristic. They might bring a claim for discrimination or something like that. But if they've got more than 2 years, you're going to have to pay out redundancy payments, potential unfair dismissal claims. It would just be very difficult, but it's not impossible, and it is something that some employers are happy to do, to take the risk on doing that. But generally, the advice would be to try and get everybody to consent to it, and in practice, a lot of people do.
Yeah. Okay. Before we wrap up, I just have to read this one out because I think it's something that probably needs to be said. It's from Danny. It's wonderful that employees have so many rights with the law standing behind them, but they do need to remember that in the main, their employer is suffering too. And it would be advisable, if they have the choice of returning to work, to try to do so if they can at the first opportunity. Otherwise, their employer may want to find ways of shutting the door on them, and job retention is the priority. And I think that encapsulates the dilemma that we're facing with this whole pandemic situation. Nobody expected this to happen. Everybody is suffering unless they've got a business that has actually particularly benefited from COVID, and there are some. So, you know, we're all in it together. I think lots of people are going to need to work together to try to help get us all forward, get growth going again, get employment going again. Because at the end of the day, it's employers that keep the country going, it's businesses that keep the country working, but the businesses themselves, of course, couldn't function without those working there. So, you know, I think this whole episode is one that is important for us all to try and pull together to get through. I'm sorry we've run out of time, but I hope that you've all found this webinar useful. Paperweight is here to support you and to lift the burden of paperwork if you're in crisis. They don't want you to get overwhelmed. We want to help you instead, or find ways to get help. Charlotte and Daniel, I think you've done a brilliant job this evening of answering all the questions that have come in, helping us all understand more about what's happening in the workplace. And I've certainly found it really interesting. I know we didn't have enough time to answer all the questions, but if any of you want to contact the office or you need further information, then we will contact you with answers to those that haven't been answered. And I believe there were a couple on pensions, but they weren't really relevant to this session. But thank you for sending those in as well. And all I can say is please make sure that if you need to, you call the Paperweight office. And if anyone has any further questions that we couldn't address or you suddenly think of, do call Paperweight. The contact details have just come up on your screen. Once again, I'd like to thank you, Charlotte, and you, Daniel, for your excellent help for all of us out here tonight. And I'd also like to thank everyone at Paperweight for all the amazing work you do, to Bela, to Benji, to all the Paperweight staff and volunteers. Thank you. And finally, I'd like to wish all of you a happy, healthy new year, full of only good things and much better times, please God, to look forward to in the coming year. Thank you again, and good night to everybody.
Good night.